Oh, hello there, class. You're back. All right. If you're viewing this video, welcome back. You remember me because I introduced myself at the beginning of every video. So I'd be remiss if I didn't point out I'm your friendly neighborhood bar grievance defense attorney, Patrick John McGinley. It's a pleasure to teach your professional responsibility class. Oh boy. Gotta get the name of the class right, don't I? But hey, maybe you're a little bit tired too while you're watching this video. By the time you've gotten to this video, you've endured, let's see, 20 hours of my lectures. You've taken a 3-hour midterm exam. You've taken 7 multiple choice quizzes. And in addition to my lectures, you've watched 9 other videos that I've assigned to you from lectures from a different professor. So man, maybe I'm a little bit tired, but you should be exhausted. Why mention that now? Well, you see, first of all, I got the casual set. Forgive me. Oh, big guy in a little chair. Got the casual set to try to set your mind at ease. But also what I'd like to do, I look awkward in this seat, don't I? What I'd like to do is give you a very short lecture. You may have noticed that lesson 13 is the shortest chapter in our book. And you've put in a lot of time. You're tired. Let's keep this lecture short. Any objections? I didn't hear any. All right, let's take a look at lesson 13. Lesson 13 talks about limitations upon the lawyer's right to practice. And that's a broadly stated theme. Of course, we've already covered licensure and having the ability to practice law. Remember, it's not the unlicensed practice law, it's the unauthorized practice of law that bars regulate, because it's not just the state bar. There can be many different sources for authorizing individuals to do tasks that might meet that vague and largely undefined definition of the practice of law. Florida Bar versus Birnbaum. Remember, we talked about that case that tried to define the mostly undefined term of what it means to say that this task is the practice of law. That was the topic then. That's not the topic today. What we're talking about here are situations or agreements to limit the right of a licensed attorney to practice. You know, these things happen. And the 23 years of practicing law, I did for very many years have the blessing of bringing civil rights claims. And some of the civil rights claims I brought were against this particular employer. This employer was an independent company separate from the theme park. It rented that country, so to speak, this particular theme park, which will go unnamed and was never a defendant in these suits, never accused by me or my firm of any wrongdoing, the particular theme park. But the theme park rented spaces in the theme park to countries, and this otherwise foreign national company had a USA subsidiary, which I found myself suing again and again on my and my client's allegations of civil rights violation. And, you know, all these cases at some point resolved. Never did a jury ever find a civil rights violation. And at one time, my associate was covering the mediation of my case, and she calls me from the mediation just to be sure, because they're working on the agreement and they're working on the terms. And one of the terms is going to be, according to this agreement, that my law firm will never represent anyone against this particular employer again, alleging on anyone's behalf that this particular employer had violated any sort of civil rights law. Was that okay to put in the agreement? I had to point out to her, not only was that not okay, but it wasn't even okay for them to ask to put that in the agreement. Respectfully so, the rules regulating the Florida Bar applied, and they adopted their version of Model Rule 5.6 of the Model Rules of Professional Responsibility. And under 5.6, you can't get involved in such a settlement agreement. That can't be a term of a settlement agreement. A lawyer is not allowed to participate in either offering or making a settlement agreement that restricts the lawyer's right to practice something or someone or a particular area of the law or a particular client. Can't restrict the right to practice within a settlement agreement. That's not allowed. So Of course, that wasn't a part of the agreement, and we had several more claims against this particular defendant afterward. But that's not permissible. That is an impermissible limitation on the lawyer's right to practice under Model Rule 5.6 and in the state law equivalents that adopt that rule. So what else is included in this Model Rule 5.6 and the state law equivalents? What else can't be allowed there? Some other things that can't be allowed are non-compete clauses. As you know, I'm your friendly neighborhood bar grievance defense attorney. It's my great honor to represent my fellow lawyers who are members of the Florida Bar or District of Columbia Bar, try to help them out when they're accused of an ethics violation. I had a client long, long ago in a galaxy far, far away just to protect her or his or their identity. Maybe I'm making this whole thing up, but this particular client who had a dispute. Sometimes these disputes come with the partnership breakup. And in this partnership breakup dispute, they were fighting about something else, but they had already produced to bar counsel the written partnership agreement. Within the terms of the partnership agreement, if this is true, maybe I'm making it up, within the terms of the partnership agreement, there was a non-compete clause. You know what I mean by a non-compete clause? You've studied this in contracts or employment law. This is where someone for a specific period of time and in a specific geographic area promises not to do a specific type of work as part of the contract, as part of the partnership agreement, as part of the employment agreement. Happens all the time in the real world, but it cannot happen as part of the hiring of a lawyer or the making of a partnership agreement. Non-competes are a violation of Model Rule 5.6. Can't have them. So that's another way that there can be a limitation upon non-lawyers and what they do for a living, but it can't be a limitation upon lawyers. We're not allowed to enter into non-competes. So that's part of Model Rule 5.6. Model Rule 5.6 also talks about selling law practices. For better or for worse, the practice of law can be and often is a business. And maybe you think that's great, maybe you think that's bad, but it certainly happens and it's certainly a possibility. It certainly is one of the things that goes on every day. So can you sell that business? Can you sell the law firm? And yes, you do have the right to sell the law firm, but selling that law firm is going to fall within some of the restrictions of 5.6. 5.6 is going to talk about selling the law firm and thought that was in Model Rule 5.6. No, it's true. It's true, but it's not 5.6. It's Rule 1.17. Let me pull up the correct rule. Okay, 1.17. Yeah, Model Rule 1.17 is where the model rules address the sale of the law practice. And you can sell the whole practice. You can sell a practice area. Maybe your firm's grown big enough and you got a civil rights division, you got a torts division, you got a some other division. You can sell just the civil rights division, keep the rest of the firm going. That's a possibility. You can sell just the torts division, keep the rest of the firm. That's a possibility. This is all permitted by Rule 1.17. But you got to let the clients, we defer to the clients. You can sell the firm, you can sell the practice, but hey, obviously, you can't sell a client. It's up to the client to decide whether they're going to go or not when the practice is sold. So you got to give some written notice to the client. They got to know about the proposed sale, right? And then they have to know that they've got the right to retain other counsel. They can stay with that practice area or with the firm after it's sold, or they can leave. They have to know that they have that right. And they got to know that about their files and what's going to happen to the files. You got to inform them about the files. Under the model rule, there's a presumption, if you don't hear from them, that their file is going with the sale. It's going with the part of the practice that's being sold. So, and if a client can't be given notice, then you can't transfer that particular client's matter when you sell the rest of the firm. So these are the issues that arise under Lesson 13. Lesson 13 is the shortest lesson in our book. And apropos, this is the shortest lecture of the semester. But yet, I hope it's been helpful to you. Contact me in the usual way. Anytime, call me. Anytime, email me. Whatever questions you might have, whether it's a question about Model Rule 5.6, whether it's a question about Model Rule 1.17, whether it's a question about anything else that falls under the topic of limitations upon a lawyer's right to practice, or whether it's any other question about professional responsibility, I'm here for you. It's a great pleasure and a great honor to teach this professional responsibility class at your law school. I'm very much enjoying it, and I hope it's worthwhile for you. I'm here to serve. So in any way that I can make this more worthwhile for you, you say the word, you tell me what to do. And from a professional standpoint, I will do it for you if it helps us both achieve our goals, my goal of educating you and your goal of becoming a great and ethical lawyer. Thank you very much. Until we meet again, may God continue to bless us all. Thank you.